No one is ever this quiet for just me. Welcome. My name is Chris Guthrie, and I'm the Dean of Vanderbilt Law School. On behalf of the school, I'm delighted to welcome you to the Cecil Sims Lecture featuring Senator Josh Hawley. Dedicated to Cecil Sims, a member of the Vanderbilt Law School class of 1914, the Sims Lecture has featured several legal luminaries, including Supreme Court justices, leading cabinet members, and U.S. senators. The Sims Lecture reflects our longstanding commitment as a law school to welcome speakers from across the political spectrum to illuminate a variety of perspectives on judging, legislating, and governing. Consistent with this vision, recent Sims lecturers have included Senator Elizabeth Warren, former Attorney General Eric Holder, and 3 members of the current U.S. Supreme Court, Chief Justice John Roberts, Justice Sonia Sotomayor, and Justice Neil Gorsuch. I am grateful to the Sims family for making today's lecture possible. In addition, I want to thank several members of the law school community, including Grace May and Natalie Souza from the Vanderbilt Policy Accelerator, Abby Wolf and Pat Artis from the Dean's Office, Dean Chris Myers, Dean Jennifer Chenal, Professor Ganesh Sitaraman, and Professor Brian Fitzpatrick. I also want to give a shout out to the Senator's staff. Today, Senator Hawley will participate in a conversation moderated by Professor Fitzpatrick, and I have the distinct privilege of introducing each of them to you. Professor Fitzpatrick, who holds the Milton R. Underwood Chair in Free Enterprise, is a graduate of Notre Dame and Harvard Law School, where he was the valedictorian of his class. So fancy. Following law school, he clerked for Judge O'Scanlan on the Ninth Circuit and Justice Scalia on the U.S. Supreme Court. He then practiced at Sidley in New York and served as special counsel to Senator Cornyn. Professor Fitzpatrick joined Vanderbilt Law School in 2007. At Vanderbilt, he has received the Hull Hartman Outstanding Professor Award and has also received national attention for his scholarship in complex litigation, federal courts, and judicial selection. He is particularly well known for his path-breaking work on class action litigation. Will you please join me in thanking Professor Fitzpatrick for serving as our moderator? Joining Professor Fitzpatrick is Senator Josh Hawley, whom it is our honor to welcome to the law school as our Sims lecturer. Senator Hawley is an Arkansas native who was raised in Missouri. He graduated from Stanford University, where he was elected to Phi Beta Kappa, and he received his JD from Yale Law School, where he served as articles editor of the Yale Law Journal. He began his legal career clerking for Judge McConnell on the 10th Circuit and then for Chief Justice Roberts on the Supreme Court. After clerking, he litigated appellate cases at Hogan for 3 years and then returned to Missouri to join the University of Missouri School of Law as a tenure-track law professor. In 2015, Senator Hawley began his political career when he launched a successful campaign for Attorney General of the state of Missouri. He held that position for 2 years before defeating Senator Claire McCaskill to secure the U.S. Senate seat he currently holds. Since January 2019, Senator Hawley has served with distinction. He is widely recognized for his intellect, for his commitment to constitutional first principles, for his scholarly and popular writing, and for a mix of conservative and populist views that have led to bipartisan legislative initiatives, including efforts to support American workers and efforts to hold big tech accountable for some of its practices. In recognition of his accomplishments as a teacher, scholar, litigator, and public servant, please join me in welcoming Senator Josh Hawley.
Senator, thank you for doing this.
Thank you. Thanks for having me.
It's an honor and a pleasure, both for me and I know for our students, and many of my colleagues are here as well. I'm going to ask you a few questions for about 30 minutes, and then we're going to turn it over to the audience for the last 15 minutes to ask whatever questions they may have of you. But as my students know, Senator, I like to start with the toughest question first. And I want to ask your forgiveness for that, but I can't treat you any differently than I treat them. One of your constituents recently became engaged. Is Travis Kelce too good for Taylor Swift?
Well, first of all, thank you for having me. It's a privilege to be here. Let me buy some time to think about that. Well, I think the real question is, my wife, who's a Swiftie, thinks it's the other way around.
I see.
I mean, is he really fit? In fact, fit for her. I will say that I've had the privilege of having one friend in particular on that team, and he tells me that they have been on the team, the Chiefs that is, they've been calling Travis Kelce Taylor Swift's boyfriend for the last 2 years. Just like, what's up, Taylor Swift's boyfriend? Good to see you, Taylor Swift's boyfriend. So now it'll be Taylor Swift's husband. I think maybe he's, what's the expression, out kicking his coverage? I think maybe
Okay.
Travis is out kicking his coverage here.
That's very kind, very gracious of you. And Taylor Swift was not born in Nashville, but she spent many years here. So we are, partial to her here. I'm curious, is this your first time in Nashville, or have you been here before?
I've been here before. I've been to Nashville many times, actually. It's a fabulous city, but I was saying to the dean just before we came over here, this is, I think, only my second time at your wonderful law school and on the campus, and my last time was when I was a student. I was here, I think it was 2005. As a law school student, there was a conference, a student conference here, and in fact, just as we were coming into the room, your beautiful staircase out here, I remember that distinctly, that sort of atrium area, but it has been 20 long years, so it's good to be back.
Welcome back.
Thank you.
And that does lead me to my next question, which, as the dean noted, before you became a senator, you were a law professor at the University of Missouri. What did you teach?
Well, my area was constitutional law. That was my area of scholarship, constitutional law, constitutional history. But when they first hired me, Brian, they said, well, we really need somebody to teach torts. So we want,
hey,
right.
That's how it goes.
That's how it goes. Now, they told me, the professors in the room will appreciate this. They hired me in, whenever, March, something like that. They told me this bit of news when I showed up on campus in July. And classes started in August. And I thought, if I'm going to know more than my students, so we canceled. My wife, Erin, we were hired together. And the real truth is they wanted my wife. My wife, some of you probably know my wife. She's a litigator. She's fantastic. I'll brag on her for just a second. She's going to argue at the court, the big court here again this coming term. She argued there last term. But so they really wanted her, Brian, and they said, Josh, you could come along in the deal. But literally, we canceled we were going to take a little vacation. We canceled it to cram, students to get ready to teach. Yeah. So I ended up teaching torts, constitutional law in various forms, and I loved it. It was 4 great years.
Do you miss it at all?
I do.
Do you ever think about maybe, in retirement, that could be a gig for you to go back to?
Well, I do miss it a lot, and what I miss, several things. I miss students. I miss the free flow of discussion and intellectual conversation. Something that I think was true at the University of Missouri, I'm sure is true here, and has long marked law schools in this country in general, is we really believe, and as lawyers we're committed to, open debate and free exchange of ideas. And I miss that. And I just have to tell you, as you look across the landscape of our country now, I think that historic commitment that our profession has long upheld and that our First Amendment enshrines is more needed than ever. So I often think of that. I've thought of it much in the last few weeks. And I miss that. I miss the conversation in the classroom. I miss my colleagues. But what I'm doing now is okay too.
It's pretty important.
Yeah, it's okay.
Yeah, it is pretty important. And I want to ask you about what you're doing now, because one of the things that you've become known for is your support for holding companies accountable through litigation.
Yeah.
And your views on this are atypical for a Republican, that you think private citizens ought to be able to sue companies when they do bad things. And I'm just kind of curious, how did you become known for this? How did you get on that side of this issue?
Well, I'll tell you what really a radicalizing moment for me. I did serve, as Dean Guthrie said, I served for 2 years as the chief prosecutor of Missouri, as the Missouri Attorney General. I had the opportunity to bring various enforcement actions. I was the second Republican Attorney General to sue the opioid manufacturers. I still remember when I filed that suit. We had a Republican governor at the time. Now, the Attorney General of Missouri is independently elected. So I had not informed the governor that I intended to do this. But I thought before I filed the suit, he's the governor, I thought I better give him a heads up. So I gave him a courtesy call. I was literally just outside the courthouse steps when I called him, and he was not happy. He said, "You're going to do what?" And I said, "Well, I said, not me, the state of Missouri is filing suit against the major opioid manufacturers." And he was like, "Well, when is this happening?" I said, "In about 5 minutes." He was fairly irate. And this became a pattern sort of with other Republican elected officials. But here's what I learned, Brian, at that time is I think that for many of these companies and these huge corporations, what do they fear? They fear enforcement, they fear the law, but above all, what really radicalized me was when I came to the Senate. What they fear above all is a jury. And here was my radicalizing moment in the Senate. I think it was 2019, maybe somebody in the room will correct me, when the FTC fined Facebook. I think it was $1 billion. It was a lot of money. And I remember thinking, naive person that I was, I thought, this is going to change their behavior. Facebook they're going to take this fine and they're going to think, my gosh, we have to change. And I still remember the next day after the fine, Facebook stock went way up. And Mark Zuckerberg said publicly, we'll change nothing. We admit nothing. We consent to nothing. We'll change nothing. And what I learned from that is watching the pattern then over the ensuing years, these companies, when they reach that size and have that power, they don't fear regulators. They can delay the regulators. They can stall the regulators. They can buy off the regulators, but they fear juries. They fear private actions. They fear your normal citizen getting into court and telling her story in front of a jury. They fear the hammer that a jury verdict is. And they fear it because they will do anything to prevent it. I mean, anything to prevent it. Right now, those companies that I just mentioned, those digital companies, are largely immune from suit. They have a liability shield that protects them, and they will spend any amount of money to keep it. So that was my turning point moment when I realized, wait a minute, the jury is so important. And the ability to set guardrails that are, I think, pro-competition, market reinforcing, but to have them done by private parties in a way that compensates victims, but also changes companies' behavior going forward, I think is just unparalleled.
And so you mentioned the regulators, and you can, if you're a big company, a lot of lobbyists and what have you, you can delay the regulation, or, you said it yourself, you can buy off the regulators. And so is this something that you see happening in Washington, companies exerting influence over agencies and getting agencies to look the other way?
No question about it. No question about it. You just look at, you can look at the membership on some of the key regulatory commissions. Take the Federal Trade Commission, for instance, in years past. And by the way, this happens with any administration, both parties. But what you'll see is you'll see a consistent pattern where folks will be on these regulatory commissions in senior roles, and then they'll rotate off of that into private work for the very corporations who they're supposed to be regulating. Or sometimes they'll go from those corporations to the regulators. It's the classic regulatory capture. That's part one. Part two is legislators. I've said much to the annoyance of my colleagues, particularly my Republican colleagues, but just true. I said the Senate ought to have a sign on the door that says property of big tech. Because the truth is, nothing that big tech strongly objects to will move across that floor. At least not, I've been there 6+ years now, 6 3/4. And in my experience, unless they sign off on it, it doesn't move across the floor. Now, we've seen this before in periods in American history. The railroads used to be like this 100 years ago. And our answer every time has been to reassert the authority of the people. It has been to subject these companies to enforcement actions by private parties and others. And it has been to reintroduce competition. And boy, I think we need to do that today.
And so what are some of the barriers to doing that you're working on? So you mentioned the liability shield.
Right.
This is Section 230
Correct.
of some communications law.
Correct.
And so are you trying to get rid of this
Yes.
altogether?
Yes.
Just strip it out of the U.S. code?
Yeah, so the Communications Decency Act of 1996 ordered the tech companies that in sort of nascent internet industry, it ordered these companies, these platforms to do ordered them to do one big thing, and then it gave them a liability shield as a sort of carrot. It ordered them to take down indecent material. And it said, if you will do that and take down indecent material, we, the United States Congress, will prevent you from being sued for that. We will give you a shield against liability. You will not be able to be sued as a traditional publisher or editor. The Supreme Court, fairly shortly thereafter, struck down the provisions ordering the removal of indecent material. They said there's all kinds of issues there, including potentially First Amendment issues. So that fell, but they left in place the shield. And it's not 1996 anymore. Those companies now are a lot different, a lot bigger, a lot more powerful and ubiquitous than anybody would have imagined all those years ago when, heck, probably half of you in the room weren't born. So what's happened is these companies now have this shield in place, Brian, and it prevents them from being sued for just about anything. So what I think we ought to do is this, and I've introduced legislation that has passed the Senate Judiciary Committee in what has got to be like a minor miracle, unanimously, bipartisan. Senator Dick Durbin and I are the lead sponsors on it, my colleague from Illinois, Democrat. But it would allow victims of child sex abuse material on these platforms and or their parents to sue the companies if the companies knew or should have known that this material was on their platform. And of course, per our traditional tort rules, the victims can show harm. So it would just reinstate the traditional rules that apply to any other company. You think about the Ford Pinto cases in years past. What happens? If a car company makes a car that blows up when you're in it, they're going to get sued. And it's right that they should be. And guess what? When they were, they changed their behavior. The tech companies never changed their behavior. I think because they can't ever be held accountable in court.
Yeah, interesting. And are there other barriers to holding them liable that you're working on besides just getting rid of this immunity shield? Are you creating some new private rights of action, attorney's fees, or anything like this?
Yes, but yes to both. In fact, the legislation I just mentioned, we call it the Stop CSAM Act. CSAM is child sex abuse material. That would, in addition to removing their liability shield, it would create a new federal cause of action to allow victims to get into court, a federal tort essentially. It includes attorney's fees provisions. And I love this model so much. I mean, I've just become known now in the Senate in the last few years in particular for saying, every time that we've got a regulatory problem, my answer is always, why don't we let people sue? I mean, why don't we allow private individuals to get in front of juries, or judges, the case may be, but why don't we allow them to get into court? Why don't we lower the barriers that over time, as you know, I mean, your scholarship is the leading scholarship on this issue, that have progressively been piled up to prevent private litigants from holding accountable these corporations, whether it's in class action lawsuits or else otherwise. Let's lower those barriers. Let's let people get into court. Let's provide for attorney's fees. And let's allow the market to do its work, which I think will bring these corporations to heel. There's other things we need to do too, don't get me wrong, but I think this is a huge piece of it.
What would the private right of action be for in particular? So is it for invasion of privacy? Is it for any harm that these companies are doing?
So I have proposed various different private rights of action, depending on the context, but you just pointed to one of them, which is an invasion of privacy. And we spell out, it basically just mimics the long-standing, and in most of our states, state tort in that way. But the idea is to try and, again, remove these barriers and allow private litigants, in this case victims and their parents, to get in front of a jury or get in front of a judge.
Is this regulatory capture that you described a problem that is just a big tech problem, or is this industry after industry after industry?
No, I think it's the latter. I think it's all of the above.
Yeah.
This is not uncommon. I mean, we've seen this. You see it in any economy, free market economy. It's part of what happens when you have large incumbents. This is why we have antitrust laws. And I just say, as a conservative Republican, I often remind my colleagues on both sides of the aisle, particularly my Republican colleagues these days, that it was the Republican Party that really invented antitrust laws. And my probably all-time favorite president, Theodore Roosevelt, was a great champion of the antitrust laws, precisely because he was for a free market. He was not a socialist. He was avowedly for the free market, but he said over and over, if markets are going to work, there has to be competition. There have to be standards. There has to be equal play on both sides. And so we've got to be able to enforce those laws. And I believe in that.
I've watched a lot of your hearings on YouTube. And I remember seeing one antitrust hearing where you were asking the witness what you could do to make it easier to sue these companies for antitrust violations. And I don't know if all of our students know this, but under our current antitrust law, the Sherman Act, it provides for treble damages. So if you win your lawsuit against a company in the antitrust space, you get 3 times your damages. And I remember you asked that witness, is treble damages not enough? I mean, are we contemplating, quadruple damages maybe, quintuple damages?
Well, yeah, I mean, I asked that because you see a comparative dearth, I think, of antitrust enforcement suits that are private compared to those that are brought by public entities. And I think one of the reasons for that is, and others have written about this, the courts have placed a lot of barriers to private enforcement on the antitrust side, which I think we need to help clear away. But, listen, at this point, I'm willing to explore just about anything. Treble may not be enough. I mean, maybe it ought to be septuple. I mean, I don't know. That's just the first Latin.
I ran out of those. I couldn't think of what was
That's
higher
the
than
highest I could
quintuple.
go. I don't know what 10 is. Somebody in here will know. But, I think at this point, my view is we need more antitrust. I'm a big believer in antitrust. We need more antitrust enforcement. I think we need to incentivize private parties to bring it for the reasons that we were just talking about. Our current enforcers, our government enforcers, listen, I happen to like state attorneys general, having been one. I'd love to see the state AGs bring more of these suits. We have very robust antitrust laws in Missouri, as well as consumer protection laws. I use those very, very aggressively. I think it's fair to say in my time there. I'd love to see more of that from the states, but I just like to see more, and it's because I think our markets are, in so many industries, are historically concentrated. We're seeing concentration levels that we have not seen for 100 years. I think that's one of the reasons that you see so much sort of market malfunction. But also, listen, if we want innovation, if we want competition, and above all, now I'm really on my hobby horse, if you want to protect the little guy, you have got to give the little guy a chance to be heard in court, a chance to have his rights vindicated, and you need an economy where you have robust competition at all levels.
And I might add, to the extent that conservatives want to get rid of a lot of the administrative state, a lot of these agencies, the fourth branch of government, we're going to have to rely on private enforcement of the law to do this accountability work. Because we're not going to have the agencies to do whatever they've been doing, as impotent as they may have been. So we're going to need private enforcement if we're not going to have the administrative state. And
this is such a good point. And I often say that you look at the agencies, and I've gotten a crash course in this in my few years in Washington. They're slow, they are costly. And listen, I don't want to disparage. I mean, there's folks there who are doing very fine work, and I think that the enforcement that they do is very important, particularly at DOJ, the FTC, but across the board. But they are very much hamstrung in the design of these agencies. And you look at what they're able to do from an ex-ante perspective compared to what private litigants can do. Private litigants are responding to real felt needs. Again, your car blows up, you're going to do something about that. You've got an incentive to do it. So the incentives are aligned in the right way. The fact that a victim at the end of the process, and maybe many victims, will get compensated is not a bug, that's a feature. That's fantastic, that's wonderful. And the fact that then a major ex post verdict will often then lead to ex ante changes in corporate behavior. Wonderful. We want all of the above. Private litigants are so much more nimble. They're so much more able. It's more market reinforcing. And so I often, when I'm having this discussion with my Republican colleagues who often say, Josh, are you proposing another private right of action? I say, what would you prefer? Would you prefer a new agency, or would you prefer this?
I think that's the way to put it. I really do. And I'm kind of curious, are you making any traction with your Republican colleagues?
Brian, I think the answer to that is yes, and I'll just give you the example of the Stop CSAM Act I was mentioning a minute ago. I first proposed a private right of action in this context maybe 3 years ago, and I remember I much to the irritation of my colleagues on the Judiciary Committee, I forced a roll call vote. I'll give you a little hint. Senators don't like to vote on stuff. Because when you vote, it's on the record, your names, and that's because constituents then can come back and say, well, why did you vote for this, or why didn't you vote for it? So senators do not like to vote. They will often spend enormous amount of time evading votes. So I had the ability at this particular time on the committee to force a vote on my proposal, this about 3 years ago, on a private right of action, and it failed, and I think I maybe got one other Republican vote. Well, heck, this year we passed this legislation, the core of which is a private right of action, and it was unanimous. Unanimous. Wow. I mean, that's a lot of progress. Yeah. And part of it is just educating people. We had so many victims come in, and I think senators were astounded to hear victim after victim say, I was exposed to this, my child was abused in this way, I was exploited in this manner. And then senators would say, okay, well, what did you get in compensation? Nothing. Well, what does your lawsuit look like? We can't sue. And I think people were just astounded. They said, okay, well, we have to do something about this.
And does this have a chance to get through the House?
I hope so. I hope it will. You know, I mean, knock on wood, it's been tough sledding in the House on all of these proposals. I think because the big tech companies have as much leeway in the House, as much authority or influence there as they do in the Senate. You know, it passed the Judiciary Committee unanimously. The next task in the Senate will be,
we're just in the committee still.
can we get to the floor?
Yeah.
So
I see.
every Republican and every Democrat in the committee voted yes.
That's a pretty good sign. It's going to do
It's
well.
pretty good, and that's what I said to my majority leader. Yeah. I said, you know, we really need to vote on this. And he said, I don't know, Josh. I said, it was unanimous.
Yeah.
Unanimous. I mean, you can't get unanimity on vanilla ice cream in the Senate these days. So we'll see.
Good for you. Now, you know, another idea that a lot of people have for making it easier to hold companies accountable through private litigation is something called third-party litigation finance. And I don't know if all the students know about that, but it's been around now for a number of years, but basically it's investors that give money to plaintiffs or their lawyers to help them finance their lawsuits. And if the lawsuits are not successful, the investor doesn't get any money back. But if the lawsuit is successful, the investor gets paid back usually a multiple of what they invested, you know, 2 times, 3 times. Sometimes they get a percentage of whatever is recovered, but it's like a non-recourse loan, it's called. So this has been around for a few years. It's very helpful to plaintiffs, obviously, to have access to this. But, you know, the United States Chamber of Commerce doesn't like it, and they've been trying to get rid of it. And I'm just kind of curious where you stand on it.
Now, I'm not in favor of getting rid of it. I'm for it. And in fact, I helped kill it, just this kind of limitation in the recent reconciliation bill that the House and the Senate passed back in, I guess it was July. There was a provision in that bill inserted on the Senate side that would have curtailed, it would have basically eliminated all of this kind of financing for private rights of action. And I just have to say, I was dead set against that. And my view is that it's currently totally legal. There are standards and rules around it. And listen, it's hard to finance these cases. I mean, it's hard to get into court. And I think that we should be in the business of, again, in a reasonable manner, but of allowing people to do that and helping them do so. And there's various reporting requirements that come with it. That's all fine. But I just think that what we saw earlier this year was an attempt to shut down these suits, which is really an attempt to close the courthouse doors. And I understand, companies, I get it, companies don't like to be sued. I understand that. I wouldn't like it either if I was a company. But that's part of the checks and balances, if you will, of our system, which is that, you know, if you do bad stuff, and this is an Anglo-American tradition in the sense that it goes back to the common law, if you do something that is objectionable, you can be held liable civilly, of course, as well as criminally, if it's sufficiently noxious. But I just think that this fundamental principle of our law, which has been so empowering to the everyday citizen, is something we want to protect.
You mentioned Teddy Roosevelt, the creator of our antitrust laws, really, and you actually wrote a book about Teddy Roosevelt shortly after law school, right?
I did, yeah.
What was that about?
Nothing to do. No, I have loved Teddy Roosevelt for years. I mean, I imagine, like maybe many of you in the room, I mean, he was a boyhood hero of mine. I mean, what is not to like about Theodore Roosevelt? I mean, a guy who, well, the answer is there are some things. But I mean, just to preempt.
No one's perfect.
Are gearing up for your questions. It's like, let me read a list of the following quotations. Like, okay, I get it. I understand. I get it. But in general, you know, this is a guy who, his personal story is incredible. He was born a sickly child. They didn't know if he would live. Then they didn't know when he got to be 4, 5, 6 years old. He had terrible asthma. When he was a college student, he was told by a doctor that his heart was very weak. This is about 19. His heart was very weak. He would likely die young, and he needed to avoid all strenuous activity. And so what he did after that is went and joined the Harvard boxing team instantly. And then he decided he would go out and train to climb the tallest mountain in the region. And then he went out and lived in the West. My point is, this was a guy who was continually leaning forward, seizing life, and also fighting for people who couldn't fight for themselves. I think one of the reasons he continues to resonate today is he was a great believer in our country, and he was a great believer in what he called the common man. And all of his agenda was geared around, how can I help the working man, the working woman, the average guy and gal in this country? How can I help them get ahead? And the antitrust laws for him were part of that.
Yeah.
You know, socialism at the time was a sort of newfangled idea. This is at the turn of the last century. Had a lot of adherents in Europe, growing number of adherents in this country. He rejected socialism, even though he was a man of great moral decency and a huge believer in justice, or righteousness, as he would have put it. He rejected socialism, but as I mentioned earlier, what he said is that we can have a free market that is for the average guy, but the average guy or gal's got to be able to protect their rights. And I just think that that's a great lesson for this time.
Was the book kind of biographical about Teddy Roosevelt?
It's a look at his ideas. It's more of an intellectual biography. So it does move chronologically, but it's not a traditional biography. It's an attempt. You know, really, honestly, I was a 20-something, and Roosevelt's such an interesting figure, and he's very different than the sort of republicanism I grew up with. And so to be honest with you, what really drew me to him later as I got into college was the constellation of his political ideas. You know, here was a guy, you read his speeches and it's like, yeah, he sounds like a conservative in some ways, but in other ways he sounds quite different. I wanted to figure out what's sort of the shape of his political views. Antitrust turned out to be so central to that, and so the book's really about that.
Interesting. So would you say that you're a Rooseveltian Republican?
Well, you know, yeah, I would say I aspire to be. I mean, I think, listen, there are things to not like in his legacy. He did later in his life, he became a huge fan of the administrative state and of experts, the rule by experts. That, I think, is a mistake. The expert, you know, typical of the progressives, sort of an infatuation with experts. I don't know that that's really done us a whole lot of good. But there's much. I would argue that the large portion of his political thought, I think, is still relevant today, is very bracing, and I think is something that we can learn from. So
very interesting. I'm going to have to read this now. You got me excited about this.
It's available on Amazon.
So I'm going to ask you about one more topic before I turn it over to the students, and I'm just kind of curious. I mean, you clerked for two amazing judges.
Yeah.
Michael McConnell, I mean, he's a superstar to us in the academy. Of course, the Chief Justice. Michael McConnell is a pretty famous originalist. He actually wrote an article about how Brown v. Board is consistent with originalism. I'm not going to ask you about that. But you know, I consider the Chief Justice, as I tell my students, a little bit of a faint-hearted originalist. And so I'm kind of curious about your views about originalism. Are you more of a hardcore Michael McConnell originalist, or, if you think this is fair, a faint-hearted Chief Justice kind of originalist?
Is this
or none of the above?
Are we streaming this? I'm sorry, Chief, before I answer. No, I would just say this. I do consider myself both a textualist and an originalist, and the reason for that is, I think, to me, those commitments are inherent in the nature of written law. You know, we have written law in this country, by and large, as the largest body. That wasn't always true. See, it was not true in the UK, where they have no written constitution. Here we have not only a written constitution, but positive law is far and away the largest body of our law. And my view is, just in the nature of law, when it is written, it has to be public, it has to be understandable, otherwise it's not legitimately binding. If you don't know what the law is, you can't follow it, that's not legitimate law. So that's why we write it down, but part of the inherent in that notion is the idea that, well, I have to be able to read it and understand it. And then you ask yourself, okay, so what's law? Is it what the drafters wanted to write or hoped to write or thought in their heads, or is it what they put on the page? And my answer would be, it's what they put on the page. And then you ask, okay, well, what if it's ambiguous? You know, where do we go to solve that? And that's the originalism piece. And my answer would be, well, you ask, what did the words meant at the time, to the public, at the time the law was adopted? And so textualism is, the law is what is fixed in the text, irregardless of what the drafters intended. And I can just say now, as a member of Congress, I've been able to see, Congress often writes stuff where if you'd ask any of the drafters, what did you intend? They would say, I intended A. But they actually wrote B. It's like, well, tough luck. I mean, B is the law, you know, and I see all the time people say, well, you know, I didn't I mean, heck, even in the Section 230 context, I've talked to some of the folks who wrote that 1996 law, and they've told me, I didn't intend this, that, or the other. I believe that. The problem is, it is the law. So my view is textualism is a commitment to the written law. Originalism is, I consider myself an original public meaning guy. You know, what did it mean to the public at the time it was written? And the answer then is, if we fix the meaning of laws that way, then if we don't like them, we change them. That's what a democracy is.
Is there anything that could be done to improve the legislative drafting process so that the intentions match up a little bit better with what they actually write down?
Better legislators, better people in law. Drafting law is very hard, I think, as it turns out, to get it right. And it's amazing how few legislators, how few members of Congress pay much attention to it. You know, truthfully, most of the laws are drafted by staff, or even there are permanent staff who are nonpartisan staff who work for Congress, and they do a great job. But my own view, and this is because I am a lawyer, is that we want to write, and I'm not saying we've never made an error. I haven't. That's not true. But we want to write with precision. And we want to write with clarity, and we don't want to outsource it to anybody else, because we want to try to anticipate. Okay, what are the various enforcement scenarios here? What are potential ambiguities where actually we didn't even see this as an ambiguity? So, you know, I mean, I think drafting is difficult, but I tell you something, Brian, that has been very bad for legislative drafting. It goes back to this administrative state, which is Congress has gotten in the horrible habit of just deferring to agencies and just writing huge, broad, open-ended grants of authorities to agencies. And what I've seen over and over it is, senators will do that. I can't speak to the House, but senators will do that as a substitute for clarifying in their own minds what they're really trying to do. They'll say, well, let's just do a broad grant of authority to the agency, and then they'll figure it out. I can't tell you how many times I've heard that.
I want to do something,
right.
But I'm not sure what.
I'm not sure what, or we can't come to an agreement.
Yeah.
You know, well, so-and-so would like it to be this enforcement. Well, so-and-so, you know what? Let's fudge it. Let's just put in really broad, fuzzy language, and then the agency they'll figure it out. And I think not only is that, I think, questionable constitutionally, but I also think it's just a very bad habit Congress has gotten into, where we're not forcing ourselves to think about what are we really putting on the page and thus in the code.
Interesting. Okay, very good. So we have some time, about 10 minutes. I promised 15, I'm sorry. For student questions, I think we have a couple of people with microphones, and they will come to you. If you just want to raise your hand, our microphone people will come to you, and you can ask your question. Who wants to start us off? I know there's lots of questions for the senator. Yes, Nick over here.
Hi, Senator. Thank you for being here. My name's Nick Wallenberg. I'm a 3L. I'm actually from Kansas City. I'll be returning after graduation.
He's going to be clerking for Judge Benton.
Oh, sure. Absolutely. Fantastic.
I wanted to ask a kind of a follow-up question about your consumer protection work. You're talking about how you're getting this bipartisan consensus for protecting consumers. What strategies are you using to bend the ear of the current presidential administration to kind of get them on board, especially in a world where President Trump has indicated he's not only against regulation, but is also concerned about kind of general litigiousness?
It's a great question. It's a terrific question. You know, something that I've said to the president many times is, I think that one of the greatest achievements of his first term was his antitrust enforcement. You know, he launched, his DOJ and his FTC launched a series of antitrust enforcements that I think really took people by surprise. I think people did not expect. He had talked in 2016 on the campaign trail about antitrust, about monopoly power, but I think, you know, given the typical Republican stance on these things, I think very few people expected him to do much. And his DOJ was actually very, very aggressive in that first term. And I've told him that I think that is one of his greatest achievements. I've been pleased to see that the last administration carried on those suits, and now the second Trump administration is doing so as well. And, you know, my pitch to the administration on these issues that you mentioned and that we've been talking about is the same that I just said. It's like, listen, I mean, first of all, what do the American people vote for? They're voting for someone who's going to return power to them. I often say that, you know, our Constitution doesn't say we the corporations. It begins we the people. And, you know, I think that is the sentiment that motivated a lot of people who I bet had never pulled a lever for a Republican before to vote for Donald Trump in 2016 and 2024. And I think one of the ways you vindicate that is that you give normal folks power and control back in their lives. And to do that, I think you need to open courtroom doors. It also, I think, will have the effect of lots of other good things, making our products safer, bringing down the price, more competition, things that we like. So that's my pitch. We'll see.
I'm also surprised, Nick, that you said the president has a concern about litigiousness. He's the most litigious person I've ever seen. Who's next? Another, yes, down here in the front. I don't know if we have a microphone, but we can probably hear it without it.
Hi, I'm Sapna, I'm a 1L. I grew up in Silicon Valley. So
Okay.
everyone I know growing up worked for tech companies.
Yeah.
And I know there's always a lot of concern with like big tech, privacy, and things like that. But I'm wondering in particular about some issues that are pretty, like, everyone kind of agrees on,
Yeah.
like, not having child sex abuse content on the internet, stuff like that. How much collaboration is there with these tech companies? Like, I know you can't probably call Mark Zuckerberg up, but I feel like there's ways to maybe convince the companies themselves to do something about these issues.
It's a terrific question. Actually, I have met Mark Zuckerberg. He doesn't speak to me anymore. We're not on speak.
This is another famous YouTube moment, right?
Well, yes. Mark Zuckerberg has been before our committee many times, and the last time he was in January of 2024 is I think what you're referencing, Brian. I said to him, there were a lot of. I'll tell you a quick story. But I will answer your question. There were a lot of victims' families in the audience that day. People who'd lost their life, kids who'd committed suicide because of what they've seen on Facebook, Meta, kids who had encountered sex abuse material. And so there were a lot of victims, and Zuckerberg came to testify and was doing so, and it got to be my turn. And I just asked him the obvious question. I said, first of all, had Facebook compensated any of these victims? And he looked at me like I was totally crazy, which is his general posture toward me. Anytime I'm sure his inner monologue is like, I can't believe I have to talk to this guy. It's just like, so he looks at me and he was like, well, no. And I said, would you consider spending any of your own money to compensate victims? And he goes, well, and then I said, have you apologized to any of the victims? To which he said no. And then I said, would you like to apologize today? They're behind you. And the parents all held up pictures of their beautiful children. And he actually, to his credit, he actually stood up, turned around, and apologized there to the crowd. Sadly, that's the best interaction I've had with Mark Zuckerberg. Our previous time he came to see me in my office and to try and talk me out of my proposals on antitrust, and I started out the meeting, I guess it started here and it went quickly here. It started here and I said to him, well, before you start, Mark, let me just tell you, I think that if you really want to do the right thing for America, you will sell off Instagram and you'll spin off WhatsApp and you'll break up your company. And he looked at me and he literally said, is this a serious comment by you? I said 100%. And he just shook his head. It was like, that was just, so we don't have the best relationship. What could the companies be doing to be helpful? They could be doing a lot. I think, here's my view, and maybe it's too jaundiced, but this is just my view of working vis-a-vis them now for the last 6 years. I think that they want to do as little as possible because the truth is they make a lot of money off the engagement of having people on their platforms. I recently held a hearing in the Senate just 2 weeks ago about kids who had been victims of chatbots. Chatbots had told them how to, I'll give you a little warning here. I'm sorry for this content, but it just is what it is. Chatbots had told them, how to cut themselves, had introduced them to the idea of self-harm, and then in multiple cases had given instructions to the kids about how to kill themselves, and they'd done it. You might say, the tech companies know this is going on their platforms. Why do they allow this to happen? The answer is those chatbots drive huge amounts of engagement. They keep people online, and that's their business model. That drives their profits. So I wish the tech companies were willing to come to the table and say, we will address our business model, we will make changes. So far, I just haven't seen them do it. And this gets back to what we were talking about. In business, as in other things, incentives are everything. And if they had the incentive, if they knew I might face a jury verdict for like $10 billion, I might have a class action suit, I think they'd be willing to make a lot more changes. I'm not saying they're bad people. I'm not casting aspersions on them, but I look at what they're doing, and I look about the fact, I'll end my rambling answer here. I look about the fact that when it comes to those Meta chatbots, for instance, and maybe some of you have seen this news, Meta actually had internal memoranda that explicitly authorized the use of chatbots to engage in quote unquote sensual, that's their word, sensual conversations with 8-year-olds. They greenlighted it. They had internal studies, I've seen them, whistleblowers have leaked them, that say that Instagram is terrible for our users, particularly teenagers, particularly young women. They knew about it. They plowed ahead. Why? Money makes a lot of money. And I just think there's got to be a higher standard than that. Thank you for your question.
Now, I don't think they're bad people either. They're profit-motivated
Right,
people, and that's what, in a capitalist society, business leaders are going to be interested in, is profits. But your job is to make sure that bad behavior is not profitable.
Correct.
And I think that's what you're working on.
Correct.
Another question. Yes, in the back over there, back row.
Thank you so much. You mentioned in the beginning the issue with the buying of regulators.
Yes.
But in the current landscape of campaign finance, it can feel like there's nothing we can do. I'm curious to hear your thoughts on what we can do to curb the coercive force of big tech, but on both sides of the aisle.
Yeah, great question. Great. Well, here, let me tell you, here's another example where I'm maybe a little out of step with much of my party. I actually think that the Citizens United case is probably wrongly decided. I'm not a fan of Citizens United. I just think that the effect of it, I can't, constitutionally, I think that case is best decided as a press case. I don't see any constitutional justification for saying that corporations, for-profit corporations that are not press, should be able to spend ungodly sums of money. If you're an individual, that's different. That's Buckley versus Vallejo. That's a different set of questions. But Citizens United, I thought it was wrong at the time, and I thought, well, maybe you could, for years I tried to convince myself, maybe you could, put it into this, put it into that, and I've just decided it's just wrong. I just think it's wrong. And I've seen the effects of it up close and personal, where you have massive amounts of money, much of it dark money, that cannot be attributed to any speaker, to any citizen, and I just think it's corrosive. So, I'm a critic of that, I have to say. On the lobbying side, listen, lobbying is First Amendment protected, should be. You won't get any argument from me about that. Should companies be able to hire lobbyists? Absolutely. But that can be true, and we can also lament the fact that these companies spend millions and millions, cumulatively hundreds of millions of dollars a year on lobbying, and it has, along with campaign contributions, and it has a tremendous effect. It has a tremendous effect. And we're about to see the same thing big time on AI. I think what we've seen on social media is nothing compared to what we're going to see on AI, because AI is going to be so much more profitable, potentially, than social media. And already you've got companies saying they're setting up AI PACs. They're going to do nothing but target people who are critical or want guardrails on AI. So I imagine a lot of that money will be coming at me, but no, it's fine. So I don't know. Is that a depressing answer? What can we do? I think we can try and push for changes in the law. I think when it comes to Citizens United, there are various, the court left open various avenues there, potentially sort of closing off. Yeah, I know. I see you shaking your head. I know. It's not a great opinion. But I think we should do everything we can. I'm all for setting up a test case to see if we can't encourage the court to reverse. I just think that was not a good opinion. I don't, as an originalist matter, I just personally think you can't justify it. I actually think the best essay on Citizens United I've seen was written by my old boss. Michael McConnell has a piece on it.
Really? He's
where
critical?
He's critical of it. And he also says he thinks it's best understood as a press case, but he thinks that it should have been a very narrow holding, and the larger holding for which the case now stands about corporate money, he thinks it was just wrong. And I think he's right about that.
Very interesting. One last question, then we got to go. Mr. Seidel over there, I see.
Hi. You describe yourself as a textualist and originalist, both in response to Professor Fitzpatrick's question and in the last question. And I understand constitutionally why you may be a textualist and originalist, but it seems like a lot of that judicial philosophy is premised on the idea that when the court says, we know this is wrong, but it's within the meaning of the statute, Congress go change it, that Congress will actually change it. You're simultaneously talking a lot about Congress being captured by big tech and Congress being, we need better legislators, to use your words. I'm curious how you square these two concepts.
Yeah, this is great. What a terrific question. I would just say this: if the question is we need better laws, and so we need some means of updating those laws, in whatever context that may be, whether it's big tech or anything else, should it be courts who are going to update the laws, or should it be elected legislators? I would still say elected legislators, for one reason, which is that you control them. And you don't control judges, and shouldn't. And I say you, and me, and nobody else. And I mean, our judiciary is an independent judiciary at the federal level, should be. We should defend that. And partly for that reason, I don't really want the judges who, I guess I have kind of a vote because I sit on the Judiciary Committee, but I vote yes or no at the committee level, and I vote yes or no one time in the Senate, and then that's it, and then they're not accountable to me anymore, and that's as it should be. But also for that reason, I don't want them writing the big tech legislation. Because I don't know what their views are. I probably, if I had to take a guess at the current court, I bet I probably wouldn't agree. If I just had to guess, I bet I probably wouldn't agree with the majority's view on it. And I would much rather take my chances with somebody I can elect or turn out of office than I would with an unelected judge. And that's not to cast aspersions on the judge at all. It's just to say that I think that she or he has their own role. So, is that messy? Yes, it is. And you have very ably pointed out that I have highlighted the messiness of it. And it is. And is it inefficient? I suppose it is inefficient. But efficiency is not our Constitution's greatest value. Liberty is. And preserving that liberty for every person in this country, and preserving it especially for people who otherwise don't have a voice, I think is much the burden of everyone in elected office, and frankly, all of us as attorneys. I mean, that's what we're here to do. We're here to give voice to the voiceless. It's the highest, the most noble part of our calling. That is a tough process. It is a messy process. It is inefficient, but the preservation of that liberty is worth it. So I don't know if that's a satisfying answer.
I can tell you it won't be satisfying to him, but it was a very...
I did my best.
But it was a very good answer nonetheless. Should be satisfying to him. We are out of time. Senator, thank you for doing this.
Thank you so much. Thank you for having me.